Good morning, judges. I will do. I would like to begin by reading out a statement. The hearing on this application is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on Justice Wayne Martin's instructions. We are here for a hearing in the matter of CFI-061-2020 before Justice Wayne Martin. The claimant is represented by Simmons and Simmons, Middle East. Lead counsel is Zoe O'Sullivan, QC. The defendant is represented by Onoma, FZE. Lead counsel is Tim Pruto.
Thank you. Ms. O'Sullivan.
Good afternoon, my lord. I appear in this matter for Barclays Bank with my learned junior, Mr. de Fremont, and my learned friend, Mr. Pruto, appears for Dr. Shetty. My lord, as you know, this is Barclays' application for immediate judgment on its claim against Dr. Shetty under his guarantee and indemnity dated the 7th of January 2015. And I can give you the up-to-date figure with interest as at 23rd of January 2021. I'm going to read it out as numbers. It's US dollars 131,049,337.48.
Thank you.
My lord, may I inquire, have you been able to do any pre-reading?
Ms. O'Sullivan and indeed all counsel, I can tell counsel I have read all the skeletons, I've read all the witness statements, I have read basically all the documents, all the applications. I don't profess intimate familiarity with each and every annexure to every witness statement, but I'm generally familiar with all of those documents, so that should expedite matters. There's no need to repeat anything that's in those materials.
Thank you very much, my lord. I wasn't also proposing to take you to any authorities unless you ask me to, but I can, of course, take the key passages. Thank you. The other thing I would say...
I've read the skeletons have been very helpful in drawing my attention to relevant authorities, so I'm in counsel's hands as to that, but I don't feel the need to go to any of those cases.
Thank you. My lord, since we're all in different time zones, we're in your hands as to when it might be appropriate to take any break.
Yes, all right. Well, I will do that. We'll go for about 2 hours. We may be reaching, I'm hoping that we might be reaching a conclusion by around then, but we'll go for 2 hours or so and see how we go.
Thank you. Thank you, my lord. Well, I propose to keep my opening submissions quite short. I just want to look at the handful of documents upon which we rely to substantiate the claim. Then I'm going to make a few headline points about the defences advanced by Dr. Shetty, but then I'm going to yield the floor to my learned friend and I will address his points in reply.
Yes.
So
I think that's convenient.
Yes. If we could look first at the guarantee, I find the easiest way to locate documents on the case bundle is to go to find and then find page. So if you go to page D1. There is the guarantee. And as you can see from its title, it's both a guarantee and an indemnity. I'd like to draw your attention to the definition of banking facilities, which we submit is very wide and was intended by the parties to extend the full range of FX transactions being entered into by UAE Exchange and Barclays. If we scroll...
Sorry, Ms. O'Sullivan, can you just help me with this? Just exactly what do you say it is? Do you say it is a facility or is it a derivative or what?
We say it falls within... well, first of all, the definition is any derivative, risk management or hedging products, facilities or transactions entered into or to be entered into with the customer. We say that it can fall within any one of those. I mean, our primary case would be derivative, but it's equally potentially a risk management or hedging product, facility or transaction.
All right. Why would it be a derivative? Can you explain? I know there are references in the submissions to what derivative is taken to mean within the industry, but of course I'm not a part of the industry. So what would you submit as the natural ordinary meaning of the expression derivative?
Well, that's I thought about that, my lord, and I wasn't able to find any guidance. I mean, I tracked down various references on the internet, but I don't know how much evidential value any of those have. All I can say is that there was no doubt in any of them. All of them took for granted the suggestion that FX transactions are derivatives.
Right. Okay.
I mean, I think a derivative
another way of looking at it would be to regard it as a facility, in the sense that what was happening was that, and what happened ultimately was that settlement of the sale of the currency took place in advance of settlement of the purchase price for the currency. Thus, to one way of thinking, and of course Mr. Trudeau will no doubt try and submit otherwise, but that would appear to be a facility in the sense that during the period between the sale of the currency and the payment for the sale of that currency, there is in effect credit being advanced, and that would, the advance of credit is ordinarily what I would take to be connoted by the notion of a facility.
This is not my expertise, my lord. I'm not sure that's right, because I think the settlement of the obligations of the parties going both ways arise as at the same date. I'm not sure that Barclays is making credit available just because the value date is some days in advance. But
they did in fact convey the foreign currency before being paid the equivalent amount, didn't they?
That's what's happened in effect. Yes. So yes, yeah. That's to that extent.
And so in effect they were on one view of providing a facility for the period between the advance of the currency sum and payment for that sum.
Yes.
Yes,
and on any view, my lord, it's a transaction. I mean, just to say, yes, on the word derivative, I think generally denotes an instrument which depends on movements in the price of an underlying index. So in that
yes.
sense, I mean, I speculate that in essence, these are transactions which depend on the movement of currency prices. Each party is taking a position on a different currency.
But again, as you point out, the word transaction is pretty broad.
Yeah. It's as broad as it possibly could be in that submission. Yeah, thank you. Right. Yes. So scrolling down then, my lord, to the clause 1. Clause 1.1 little 1 is a secondary obligation, a guarantee properly called, and little 2 is a primary obligation, an indemnity. So we rely on both of those. The third, little 3, doesn't actually arise in this circumstances. What it is, that's a sort of hybrid which provides that if the underlying sum becomes unenforceable or illegal for any reason, a primary obligation, as it were, springs up. Now, that's not the case here, but we point out, we simply draw attention to that because it answers any suggestion that the invalidity of the underlying transaction would amount to a discharge of the guarantee. And then we point out at paragraph 2, if you scroll down now to page D2, there's a further separate indemnity.
Yes.
So, and then just scrolling rapidly through, clause 3 contains what I've called the standard anti-discharge wording, which is intended, amongst other things, to avoid the application of the rule in Holman-Brunskill. Again, it doesn't arise here because there hasn't been any underlying variation or amendment, but it's clearly intended to preserve the guarantee in the face of an underlying variation. And then if we get to clause 4, you get, as it were, an express advance consent by the surety to any change in the banking facilities. We don't need to rely upon this because it's so wide, but we could potentially have relied upon this had there been some change, but there isn't in our submission. Then moving on down rapidly to clause 16, which is on page D6, there's a costs provision on which we will rely should we succeed in this application. And then clause 17.4 has also arisen. That is the conclusive evidence clause. My learned friend, such a clause is not a silver bullet, but in my submission, that is exactly what it is. It is a contractually binding agreement that in the absence of manifest error, the sum stated or demanded is due from the principal debtor. And then just for completeness, you'll note the governing law clause at clause 19 and the jurisdiction clause at clause 20.2. And then finally, on page D7, you can see the signature of Dr. Shetty, and there's no dispute that that is genuine.
Yes. Yep.
So I'd like to move on to the master agreement between Barclays and UAE Exchange. Now, as your lordship will know, the ISDA master agreement is perhaps the best known standard form contract in the world. There are two versions, the 1992 version and the 2002 revised version. In the present case, the parties adopted the 2002 terms. As I'm sure your Lordship is also aware, the master agreement is the umbrella under which individual transactions are entered into by the parties. And the standard form is a template which contains a number of options that the parties can choose between, and their choice of options and other specific terms agreed upon them, such as the termination currency, are set out in the schedule. Now, if we go to D388, you'll see the standard form template.
Just bear with me. Yes.
And as you can see recited in the preamble, the contract between the parties comprises the master agreement, the schedule, and the documents and other confirming evidence relating to the individual transactions.
Yes.
Now, as to the specific agreement entered into in this case, we find that at D354.
Isn't it? Yes, I have that.
Sorry, I'm afraid I'm having some difficulty getting there. Yes, there we are. So this is the actual one. As you can see, it's dated the 3rd of August 2012. And if you scroll down, this is just the first page. And then the next page, if you scroll down, is just the signature page. And everything else between pages, I think, well, up to page 28, has not been exhibited here. Now, so my learned friend complains that this document is incomplete, which is true, but not to the point. Because when this was exhibited to Mr. Homburger's affidavit at the time of the application for the freezing order, the template wording was missed out because it's very long and it doesn't change. So it just went straight to the signature page. And if you look down at 356, there you can see the schedule.
Yes.
So Dr. Shetty's lawyers complained about the omission of the template pages. So we provided the full document to them on the 19th of October 2020. And as you could see, the standard template wording is in the bundle. At D3.
I'm just struggling to follow this. So I've got the signature page.
Yes,
and
if
it
you scroll
incorporates. Yes, and so then it incorporates the 2002 master agreement and schedule.
Correct.
Are together referred to as the master agreement. Now, after page 2, what's that follows? There's the schedule.
It's the schedule, yeah, D356. That's the schedule.
But then the master agreement wasn't included.
Well, it wasn't exhibited. I mean, obviously it was in the original. It wasn't exhibited. Obviously, it forms part of the agreement, but it wasn't exhibited in the bundle.
Right. But so the master agreement is that which you took me to earlier. That's the 2002 master agreement. Yeah,
it's about 28 odd pages of standard form wording. And as I've said, there are lots of options. And you can see when you get to, if we look at the schedule, for example, Part 1A, this tells you all the choices that the parties have made they've picked from the menu. And this is their order, as it were. So they've specified, for example, well, the one I'll show you, if one scrolls down, yes, on 357, for example, they've chosen not to include automatic early termination, and they've chosen termination currency means United States dollars. So that's why this claim is in dollars. I mean, you know, the form is adaptable to a huge range of transactions and circumstances.
And the assertion is that you lost portion of the agreement. I take it from what you said, you dispute that. You just say it wasn't exhibited, but now so there was a version of the master agreement that was part of the document signed in 2012?
Yes, absolutely. And my point is this, I mean, the master agreement is the master agreement. It doesn't change. Right. It's standard form wording that never changes. That's the whole point of the master agreement, is it's exactly the same. No one ever alters it. You put the specific terms in the schedule. If you want to, you have to enter into an amendment agreement, but nobody takes their pen to the ISDA master agreement. Right. That's the whole point of it.
Yes.
So, you know, we had it. It's available on the internet. It's not free, but anyone can find it on the internet. There's no mystery about what the terms are. And so the suggestion that you don't have before you the terms that are agreed between the parties is completely wrong. You do. It's simply that for convenience, we didn't bother the court with all the standard form wording, but we will be looking at it today, so it's in the bundle.
Good.
So I didn't want to it's a complex agreement, but we might have a look at a couple of the standard form clauses. So if we go to D 391, this is back in the what I call the template.
Yes.
You see, for example, clause 5 at the bottom, events of default and termination events.
Yes.
So this, and that includes, for example, A1, failure to pay or deliver, which is what we rely upon in this case. Now, if you go to 396, D396, again towards the bottom, these are the provisions for early termination. So essentially that, as in this case, if there's an event of default, that gives the non-defaulting party the right to specify an early termination date. Because at any one time, some of the transactions are likely to be outstanding. I mean, they may have been entered into, but the value date hasn't arrived. So they have to be closed out. And then clause 6D, if we go down to the next page, tells us how the it's right at the bottom of D397. It tells you how you calculate the early termination amount.
Yes.
Or rather, it tells you that you have to. The actual calculation is at the next page, which is 6E, payments on early termination. Now, I mean, it's all a bit cold towel stuff, but essentially, the early termination amount has two elements. That's the closeout amount, where transactions that haven't yet arrived due for performance have to be closed out early. The parties have to, well, the non-defaulting party has to close out the transactions and calculate what amounts fall due from either party in respect of those. Those are the ones that are still outstanding. And then there's also the unpaid amount, which is sums that have already fallen due for payment. And of course, that may involve both parties owing sums to each other. So they're netted out, and the net sum is the unpaid amount. And you add those two together to get the early termination amount. And I'll show you in a moment what it was in this case. But it can, in theory, be a sum due in favour of the defaulting party, depending on the circumstances of the transactions. I mean, that's obviously not what's happened here. There's a substantial sum in favour of Barclays, but in theory, it can go either way. Right, so looking then at the particular transactions in this case, as you know, the claim in this case arises out of a series of FX trades entered into between Barclays and UAE Exchange between the 6th of March and the 13th of March 2020. And the trades were placed by UAE Exchange using Barclays' automated trading platform, which is called BOX, to which it's had access for many years. I mean, the account is obviously subject to predetermined parameters, but if the trade's placed within the parameters, no human intervention is required at Barclays' end. So Dr. Shetty's lawyers asked for all the confirmations of the individual transaction to be produced, and so they were produced. And Mr. Vergy has listed them in Appendix C of his report, which is at E70. Now, you'll have to rotate right with this. So I go into View and then rotate right.
Yes.
So we think this is largely accurate. We've identified one double counting error on this page, which I'll just show you briefly. About 12 entries down, it's the first entry for the 10th of March. Do you see it under deal date?
Just bearing my pages, yes.
Sorry, of course.
No,
so
right.
The first deal date with the 10th of March is for a sum of 329,000 US against 450 Canadian. Do you see that?
Yes, yes.
If you go down about 4 entries in the schedule, you see the same transaction.
Yes.
So we think that Mr. Vergy has double counted 2 of the, one transaction. One of the things he says in his report is that he couldn't reconcile the figures for 10th of March, and we think that's why. But other than that, on the whole, we think this is an accurate account of the individual transactions. And you can see that most of them were spot trades because they had a fairly short interval between the deal date and the value date. But some of them are in fact forwards, and there's quite a long interval between the two. And just to show you by way of example, the first trade on this page, the deal date was the 6th of March, the value date was the 10th, and Mr. Vergy has designated that as failed, which means that UAE Exchange didn't honour its side of the bargain. They defaulted on payment. Now, most of the transactions in this list are failed, but if you scroll down to the final page and rotate it right again, you'll see that some of them are described as closed.
Yes.
So
what's that mean?
It means these were all trades where the value date fell after the early termination date, so they were closed out early.
Right. So that means that the foreign currency wasn't provided, or what does that mean?
It means that the Barclays went into the market and entered into an offsetting transaction so that to as it were, reduce the liability to zero, or to offset the liability.
Right.
I mean, these are dynamic, so they have to do their best to bring those obligations to an early end, and that, as it happens, we will see shortly, the closeouts of the transactions resulted in a small net sum due to UAE Exchange.
Yes. It was about $1,000, I think, wasn't it?
That's right. Yes. So I mean, but it's a two-part exercise. So those ones marked closed, but were closed early and netted off, and the net result was a small sum due to UAE. Exactly.
Yes.
Right. So going then to page D9, which is the notice of default.
Yeah.
Sorry. And that was, that's the 24th of March. So this notifies the counterparty, UAE Exchange, that it's failed to pay certain amounts, including but not limited to those amounts set out on the dates below. So this isn't a list of transactions, it was a list of certain transactions, but it doesn't purport to be a complete list of all the sums due.
Yes.
And in fact, you can see the first of the one, we saw that, US dollars, $329,000. That's one of the failed transactions we just saw.
Yes.
And I haven't totted up the full amounts because they're all in different currencies. So on the second page of this letter at D10, Barclays required the default to be remedied by close of business the following day, which didn't happen. So if one goes to D11, which is the 26th of March, Barclays serve a notice of early termination, designating that date as the early termination date.
Right.
Which meant that it then had to close out the outstanding transactions. And then the next document is the statement of payment on early termination, which is at D13.
Yes.
And as you can see, that specifies the amount due, the principal amount sum on this paragraph 3 as 129 million odd US dollars. Now, the annex, if you scroll down to D16, that tells us how they calculated the early termination amount. And as I said, there are two parts. There's the closeout amount, and that tells you what they did. We followed the methodology specified in order to arrive at a value. The information obtained as follows, and as it was a small amount in favour of UAE Exchange. And then there were the unpaid amounts. So they identified the sums owed by Barclays to UAE Exchange, which is a negative sum, 24 million odd. And then it owes the sums, sets out the sums owed by UAE Exchange, and those are netted off against each other. They don't specify the maths, but then when you take account of the $1,000 odd, that gives you the early termination amount of $129.5 million. So we do give credit for the sums due. Yeah.
Do you say this is the conclusive certificate within the terms of the guarantee?
Yes, we do. We say this, and we also rely upon the demand, which I'm going to go to in a moment. But we say, yes, this is the conclusive statement.
Yes, all right.
So going now to the demand, which we also rely upon, which is at D19. This is because of UAE didn't pay. The UAE Exchange did not pay, and so this was served on the 28th of April.
Yes.
And the sum's gone up a bit because of interest.
Yes.
Now, as you know, there was quite a lot of correspondence after this. I'm only going to show you the first response from Dr. Shetty, which was at D24. And he was represented at that point by BSA Ahmad bin Hazim. And he says, I mean, you know, that basically said it was allegedly signed. We put Barclays to proof of the signature of the guarantee, and that issue has gone away. But there's no the doubt that he received the demand, and he hasn't paid a penny. Now, as your lordship knows, after this point, Dr. Shetty changed his legal representation to Onima SED, who represent him at the moment. They've advanced various defences on his behalf in correspondence, but we went through those in the skeleton, and I won't go through them now. Mm-hmm. So in our submission, those documents show that Barclays has an unarguable case to be paid under the guarantee in the sum shown on the face of the demand and the statement, plus interest since the 28th of April 2020. Now, as the test for immediate judgment, it is common ground that it's in the interest of justice for the court to grant immediate judgment where there's no defence with any real prospect of success. Anything else simply increases the cost and effort for the parties, wastes the time of the court, and makes other litigants wait longer than they have to for their trial dates. As Lord Justice Mummery memorably put it in the Doncaster Pharmaceutical Group case, everyone agrees that the summary disposal of rubbishy defences is in the interest of justice. The court has to be alert to the defendant who seeks to avoid summary judgment by making a case look more complicated or difficult than it really is. I won't take your lordship to it, but the reference is G200. We say this statement accurately describes the defences advanced in this case. They are all hopeless. And before I hand the baton to my learned friend, I want to make a few headline points. First, yes. This is not a case where dishonesty can properly be alleged against Barclays. There is no reasonably credible evidence of dishonesty. In his second skeleton, my learned friend seems to disavow any claim of fraud against Barclays, but he's still trying to say that Barclays deliberately overrode internal controls to keep trading with UAE Exchange after it knew that UAE Exchange was in default. So what we call the connivance argument is still being pursued. The theory now seems to be that there was a rogue trader in Barclays' FX trading department who was deliberately overriding the system in order to line his own pocket, knowing that Barclays would pick up the bill. And my learned friend is on very thin ice in professional conduct terms in advancing such an argument in the absence of any evidence whatsoever. There is no proper basis for drawing any inference of dishonesty against Barclays as a company or against any individuals employed by Barclays. My second point is that negligence on the part of Barclays does not afford Dr. Shetty any defence. This was made clear in the decisions at first instance and the Court of Appeal in the Bank of India and Patel case, to which we've referred in our submissions. The court considered that the bank had failed to take steps designed to protect it against loss, but this did not discharge the guarantor from liability. Only connivance, that is dishonest collusion with the principal debtor, will discharge the surety. At its highest, the case against Barclays is that it ought to have cut off UAE Exchange's access to the trading platform after the defaults began on the 10th of March, earlier than the 13th of March, which is the deal date of the last trade. Any argument that Barclays should have withdrawn access before any default is very problematic. Despite what Professor Alexander may say, because that might well have exposed Barclays to a claim for breach of contract. But let's assume, for the purpose of this application, that Barclays did neglect its own best interests. Let's even assume that, as Professor Alexander suggests, it was guilty of regulatory breaches. I want to be clear, I'm not accepting that there were. But for the purposes of argument, even if that were the case, none of this affords Dr. Shetty any defence. Barclays does not owe him a duty to prevent trading by UAE exchange, which might expose him to liability under his guarantee. If there are regulatory breaches, that is a matter for the regulator. These are not duties owed to Dr. Shetty as guarantor. And if any party has suffered from any regulatory breach, it is Barclays itself. My third point is that there's been no variation of the underlying contract between Barclays and UAE exchange. So there is no occasion to consider the ambit of the anti-discharge provisions or the purview doctrine. In his second skeleton, my learned friend seems to be suggesting that because Barclays continued to permit UAE to exchange after it was in default, there must have been a variation to the standard ISDA terms. As a proposition of law, that is simply incorrect. And the fourth point is that the attempt to suggest that there could be a defence of illegality misunderstands the law in this area. And the basic statement of the illegality principle remains that of Lord Mansfield in the 18th century case of Holman and Johnson. He said, "The principle of public policy is this: ex dolo malo non oritur actio. No court will lend its aid to a man who founds his case upon an immoral or illegal act." That statement was affirmed by the Supreme Court in England in Servier and Apotex at paragraph 64. The reference for the record is G365. So there has to be some relevant unlawful conduct which would justify denying a party recovery to which it would otherwise be entitled. In this case, Barclays' claim is not founded on an illegal or immoral act. It is a lawful claim under a lawful guarantee in respect of a debt incurred pursuant to lawful FX transactions. To say that there is a public policy in the proper regulation of banks is true, but it doesn't begin to make out any legal ground of defence. Of course, regulation is important, but in England, Parliament has entrusted the role of policing regulation to the regulator. Public policy does not allow debtors like Dr. Shetty to escape from commercial obligations willingly assumed by them by mouthing platitudes about regulation. On the contrary, there is a strong public policy in favour of holding contracting parties to their bargains.
Yes.
Finally, I observed that yesterday we were provided with two further authorities relating to the interpretation of the 1992 Master Agreement. These are two authorities, both at first instance, in which different judges of the English Commercial Court took opposite views as to the meaning and effect of the netting off provisions of the Master Agreement, which poses an interesting problem in terms of precedent. I do not know what point is being advanced in reliance on these two mutually inconsistent decisions. My learned friend has not referred to them in his skeleton. The whole point about having two rounds of skeletons in this case is that each party should have advance notice of the arguments and authorities relied upon by the other. I therefore put down a marker that if a new argument is going to be raised, of which I have not been given notice, I will object to the point being taken, but I will listen and see what the argument is. And with those observations, I hand over to my learned friend.
Thank you, Ms. O'Sullivan. Mr. Trudeau.
Yes, your lordship's indicated that you've had the opportunity to read in, as it were, yes. And I won't belabor, therefore, the process of going through my second skeleton argument in particular. But I'd hoped tolerably clear across the two skeleton arguments, but in particular the second skeleton argument, that the defendant says there's been no proper attempt by the bank to tell us how it is that it fits within the definition of banking facilities. Your question was not surprising to me. early in the case as to how it does fit. Now, I had understood best that I could from a learned friend skeleton arguments that they describe these FX spot transactions as hedges. Then when you asked my learned friend to explain, she said that they were derivative trades. She may say that they're hedges by derivatives now, but that's not what her skeleton says. Mr. Homburger's evidence says that they are hedging. When you ask my learned friend about what constitutes a derivative, the response that I'm paraphrasing, of course, was that there was no recognized definition of a derivative. Well, we fundamentally disagree with that. And if she'd ever said that before, we wouldn't be raising it now. I obviously don't know and don't presume to ask whether you intend to deliver a decision today. But if you did not, we would certainly be in a position to provide succinct submissions on that specific point, because it's difficult to see how a tribunal faced with the dilemma that you're now faced with is fairly tasked with the decision as to whether or not these trades fall within banking facilities without an accurate explanation of the question or answer to the questions that you've just raised.
What about the words or transactions? There were transactions between the customer and the bank, clearly.
And I'll come to the consequences of them being individual transactions, but that's not what my learned friend says. And if there is to be any significance attached to her claiming that these are derivatives, the court's entitled to an explanation as to what that actually means. We don't accept that there's no definition of that, and we're surprised to hear it said.
But why do I need to go there when the word transaction is so wide, as Ms. O'Sullivan pointed out? There was clearly a transaction between the customer and the bank, wasn't there?
It's simply, it's as I'll come on to deal, it's simply a trade. We don't accept that it's a properly described, it's a transaction.
Why not?
The definition.
How else would you describe a trade if it isn't a transaction?
Well, you characterized the transaction as something that was being provided before value for that was being paid. And that's not what a spot trade, I should say, consists of, because I will take you to some of the confirmations only as examples, and the value
leave to one side whether I accurately portrayed what was going on. Surely what was going on, however it's portrayed, would come within the natural and ordinary meaning of the word transaction, wouldn't it?
Well, we don't accept that they're individual transactions.
Well, what were they?
They were trades under the umbrella agreement of the ISDA.
All right. Well, aren't trades under the umbrella agreement transactions?
I'm sorry. Yes, they are. I beg your pardon. Yes, they are.
All right. Well, then that's the end of the point.
In relation to what my learned friend said before, in relation to derivatives, which is the way that they describe them, certainly if you were to consider that, we would ask you to consider the possibility of hearing from us further on the question of derivative and whether or not there is a definition.
Perhaps I misunderstood you, but I thought you just conceded that they were transactions.
Yes, they are transactions.
Well, then why do I need to worry any more about this point about banking facilities then?
Well, because just one moment, please. I'm sorry, would you? I'm just taking instructions. If you just give me a moment, got a lot of electronics. Well, I'll develop the point, but it's important to understand that they are spots and not derivatives because it's settled the same day.
Why is that important? I don't understand why that's important.
Well, because if they're settled the same day, you'll see how as soon as the 11th of March at the latest, there were defaults under the ISDA, and I'll take you through the ISDA. There's a world of difference between a forward trade, which is the derivatives as I would recognize the description, potentially, because there is an underlying index, and a spot trade, because a spot trade in this context would lead to a default under the ISDA by the 11th of March. If there's a default under because it settles the same day and the confirmations make that clear. It's an apples and oranges comparison.
My point, Mr. Prideaux, perhaps I need to step back and explain what I mean by, I'm wondering why that's significant. Ms. O'Sullivan and the documents and the skeleton point to a strong prima facie case in favour of the bank. Leaving aside where the legal onus lies and matters of that kind, in practical terms, in order to resist judgment, you have to identify to me some arguable, I'll leave again the debate about the standard that has to be met, but you have to identify a defence that justifies a trial. Now,
yes.
Before you start telling me about the differences between spot trades and forward trades, what I'd like to know from you is how that difference is relevant to the identification of any defence on behalf of your client.
I'm happy to deal with that head on, as it were, if I have the opportunity to take you to the ISDA, and I'll have brief submissions to make about the notion that we're not entitled to the missing 27 pages. But leaving that aside, when one looks at the ISDA that we've been provided in full copy, if a trade settles the same day and is taking place under that umbrella agreement, there is necessarily, and I'll take you through the document, there is necessarily therefore an event of default, because a condition precedent under section 2 of the ISDA is that there are no events of default. They're trading in some way that isn't within the ambit of the ISDA.
So what's the defence? How does that manifest itself in a defence to your client? Tell me what the defence is.
Because if they're not trading under the ISDA, they must be trading in some other way. It's not difficult to understand why a condition precedent under the ISDA is the absence of an event of default, particularly if you have someone guaranteeing the obligations under the ISDA.
Are you saying anything other than there's been a breach of the ISDA, an event of default under the ISDA?
I'm saying quite a lot more than that, but in relation to the ISDA,
I'm not understanding you. Perhaps you could explain what more you're saying.
Well,
why don't you just take me to the ISDA and explain it in that way?
Right. Well, that I would welcome the opportunity to. And I wonder if I could ask how many screens you have access to, because this is a little less painful if you have 2 screens. I can't tell, obviously, from where you're sitting.
No, I've only got one at the moment. I could open a second, but I've found in the past that can get a bit problematic. But I can jump from one to the other pretty quickly. You just give me page numbers. I
apologise in advance for a little need to do that. And I should say, for reference points perspective, this is dealt with in some detail in the second skeleton argument. So I'll just give you the sections of the skeleton argument that it's dealt with. Paragraph 6 to paragraph 21, which is the summary section, and then in more detail paragraph 49 to 72, and I'll just give you the document number in A. That's document A8. I don't need to take you to the document. It's document A8.
Yes, I've
and
read
it starts at A48. But if I could now take you through the relevant part of the ISDA, there's no question, of course, that Barclays' case turns on the fact, or is based on the fact, that the ISDA is part of the FX trading agreement, the suite of documents that they rely upon. The witness statement of Mr. Homburger for the bank exhibits it. Now, I'd like to take you, please, to the document itself. You have seen some of it before, but I want to squash this point that there's idiocy, in effect, in us asking for the missing 27 pages by demonstrating to you that they're plainly different on the face of the document. If one goes to D and to, if I could take you to D4, document D14, which is...
What page number?
It's page number D354 and D355.
Yes, that's the ISDA. Yes, I've got it.
You'll see that the last words on D354 are elsewhere in the doc.
Yes.
And then
sorry,
if you
the
go,
last words on 3.
If you go to 355, the first words are waiting period. Now, obviously, I'm not trying to demonstrate that they're not sequential, because everybody accepts that. Whilst we're on D355.
Sorry, D354. What were you saying about 354?
354 is the first page of the 3rd of August document 2000.
You said something, the last words about 354. The last words on 354 are elsewhere in this agreement.
Yes, agreed. If you go to the next page,
yes,
the first words on 355 are waiting period.
Yes.
And then if you look at the execution date on 355, it's some 5 months after the date of the document. So assuming then that you can't look side by side, if you then went to the full ISDA agreement, and that's further on in D, and that starts at document 17.
Page number?
It starts, I beg your pardons, D388.
Yes.
It's a lot easier, I'm afraid, for me, I expect, because I have the documents side by side now. But if you remember, D354 ended with the words elsewhere in this agreement.
Yes.
D388 seems to have that paragraph in, but it's the penultimate paragraph in that page. And then, if you'll just bear with me, I'll go down to the equivalent in this document to D355, and that in fact is, I'm sorry, the pages of this seem to take a period to load. Forgive me.
Yes.
Yes, if you go to D401.
Yes. D410, you mean?
No, it's D401.
Well, if you're looking for the bit that's got waiting period and the signature clause on it, isn't that on D410?
Different page, I beg your pardon. I'm sorry, Mike. I think it must be yes, it's D10, or sorry, D410.
Yes.
You'll see that waiting period does appear, and the wording seems to be the same as the top of the page in D55.
Yes.
It appears in D410. Now,
so there's been different formatting of
there's
the
been different
master
formatting,
agreement.
but it's not a strange or unreasonable request to have made, and the court is entitled to wonder why there was never a response other than, in effect, you don't really understand. It's a standard document as to where the missing 27 pages are. Now, for today, I have no choice but to deal with the document that appears at D17, the document that starts at 388, in terms of what I'm going to take you through. But it really isn't something that we should have been begging for when we wanted the full document. Now, if I could ask you to look then at D388, because it's the only way, dealing with a document that I know is the wrong document, it's the only way I can take you through the analysis as to why there are defaults under the ISDA. And to your question, where does that get me? Well, it gets me to the issue of what agreement was running if they clearly were not operating in relation to the ISDA. Now, if you could then turn to page 388, you'll have the beginning of a complete version of the master agreement, albeit not the agreement that was signed by Mr. Shetty. If you look then, and I should add, I checked, I understand that it was you, Your Lordship, who heard the ex parte freezing application.
Yes.
It wasn't executed by Mr. Shetty, I should say, of course. He's a guarantor, I beg your pardon. He didn't sign the ISDA, of course. No one's suggesting that he did. That was my error. But I understand that you heard the ex parte on notice freezing order application. Of course, council has a heavy responsibility in an application like that. And there's a line of cases about full and frank, and not only about full and frank, but it not being satisfactory to bury within documents what should be actually explained. I've also seen the skeleton argument for that. In fact, it was an amended skeleton argument. I don't think I've ever seen an amended submitted skeleton argument. But the point is, nothing was said about the fact that there was an incomplete ISDA. It was relied upon, and the affidavit in support of that application failed to make it clear that there was a missing 27 pages from the original ISDA. But if one now looks at the ISDA that I'm going to have to use, we'll see that the materials start on page 388. Again, apologies because you don't have the ability to leave that where it is. But before I take you through the ISDA, I was going to take you to a single example of the confirmations, which says a good deal about the way that these FX trades are settled. So if you will just bear with me, I'm afraid, can I ask, I don't know if you're able to bookmark in any way where you are now.
So I can come back quickly.
I would like you to go, please, to page.
Show me the page number you want, and I can get between pages quite quickly.
Right, thank you. D792. That's D792.
Yes, I'm there.
You seem to have the advantage over me at the speed that you can get from one to the other. Please bear with me. And I should say that there are further examples given in my skeleton argument, but I don't intend to take you through them all. I just wanted to take you through a single one so that you have a good idea as to what's behind the ISDA, as it were, what's drawn upon. So at D792, there's no significance in the words, the name Daniel Kenny. He's a Simmons and Simmons lawyer. I think he must have just been the person to print these out, but you can see straight away that this is a Barclays sourced document. You see the logo there.
Yeah.
This is one of the many trades that you were shown in the E bundle that Mr. Vergy had put on a schedule. So this is the 10th of March deal date and value date. And you'll see the information is in block capitals as you scroll down the page. Please advise immediately, etc., if there are any incorrect details. Now, just so that there's a good deal of clarity in the terminology, and so that there's no doubt at all that this is a same-day trade, I just explain this document, and obviously it's not a unique document in the sense that the processes for the FX spot trades are all similar. It's accepted in that schedule that there are some forward trades, but the vast majority of the trades are spot trades. In this trade then, which follow a standard pattern, Barclays sold 400,000 sterling, our sale. You see there, our sale, 400,000 pounds in sterling. Our purchase, that's what they get paid under the deal by UAEX in return for that of 521,000 US and some extra dollars. The value date and the deal date are the same. So these are sort of classic FX spot trades. All happens on the same date, and that's not a difficult thing to understand when you see the scale of value being transacted across a wide range of trades. Now, if I then could take you back, please, to the 388 page.
Yes.
I'll just return there, and then we won't be moving around documents for.
Yes, I'm there. Thank you.
Yes. So if one looks then at the bottom of 388, and I've given several other examples of confirmations in the skeleton, the second skeleton, at paragraphs 9 to 12, page A48. But these are, if one looks then at 388, 2A3 and 2A2. Payments under this agreement, I'm reading from 2A2. Payments under this agreement will be made on the date due for value on that date. So, of course, date due for value in the example that I've just shown you.
Sorry, where are you reading from now?
Same as the deal date. The value
where are
date
you reading from
date.
now, Mr. Prudhoe? Mr. Prudhoe, where are you reading from?
So if I'm still on 3A2,
2A2, are you?
2A Roman 2.
2, all right.
There are lots of twos, I beg your pardon. So it's the sub paragraph that says payments under this agreement.
Yes, I've got that.
Will be made on the due date for value.
Yes.
So if one takes the if one takes the 792 example, the 10th of March, the deal was done on the 10th of March, the value is due on the 10th of March. And of course, if you look at 1, Roman 1 above it, each party will make payment or delivery specified in each confirmation. So the confirmation says the 10th of March as well. If one scrolls down then to the last paragraph on that page.
Yes.
Each obligation of each party under section 2A Roman 1, which I've just read to you, is subject to the condition precedent that no event of default or potential event of default with respect to the other party has occurred or is continuing. So that then raises the issue about whether or not there has been an event of default. So there's a condition precedent for the trade that there isn't an event of default. And to find...
Well, it's not a condition precedent for the trade, it is the performance of the obligation.
Well, the performance of the obligation...
Understandably, this provision says if the other party is in default, you don't have to perform. Now, that's nothing more than the enunciation of normal, depending on the nature of the default. It avoids having to go into the question of whether there are correlative obligations.
Right.
It's simply saying that in this particular case, where the other party is in default, there is no enforceable obligation to perform. That's what it's saying, isn't it?
I'm sorry. I'm sorry. If you would please bear with me. Sorry. So we then go to yes, I agree with your statement of the law respectfully. If you then go to event of default, and that's on 5.
Clause 5.
Clause 5, which is starts at page D391 and goes into D392.
Yes, I've got that.
Failure to deliver or pay.
Yes.
And I'm reading now from the top of D392, Roman 1.
Well, I've read that. You don't need to read it out. I've read it. Thank you, Mr. Prudo.
Right. So my simple point is that as soon as the clock strikes midnight on March the 10th in relation to a transaction that was due for payment in that same deal date, I'm sorry, and on that deal date, I'm sorry, there has been a default. There's been a failure to pay under section 5 of the ISDA.
Well, I don't think that's controversial.
Right. So if it's it's not been said to me that it's accepted. But if
they gave you a notice of default. They gave you a notice of default and early termination based upon a whole raft of defaults.
There's the problem.
I don't understand to be controversial. I might stand to be corrected, but I don't understand to be controversial. They say you didn't pay.
Well,
it's as simple as that.
Well, the fact is, the evidence, although it's not clear whether it was the 16th or the 17th of March, the evidence is that they didn't even know about the failure to pay on the.
But that doesn't. But that's a different question. The question we're dealing with now is whether there was a default, and I'm just saying I don't know why you're going such a long-winded way of putting forward the proposition that there was a default. That's what this case is based on. What I'm struggling to see is
if there was a default
point.
as at the 11th of March, let's say that there were no defaults on the 10th of March within this range, but if it's accepted that by the 11th of March they were in default, whatever the trading relationship was between Barclays and AUX wasn't within the ISDA.
Well, that's
because
just not
they
right.
were trading whilst AUX was in default.
But that doesn't take them outside the agreement. All it means is that they have performed their obligations, notwithstanding the fact that under the terms of the agreement, once there was a default, they weren't obliged to do so. It doesn't mean that there was some other agreement or different agreement. It means that they've chosen not, by reason of whatever it might be, lack of knowledge or whatever, but they have simply chosen not to exercise their right not to perform.
But
they didn't exercise that right until some days later.
Well, there were.
That doesn't mean that there's some different agreement, does it?
I'm anxious not to talk across you.
Why does that mean there's some different agreement or it's outside the agreement? It's open to a party to choose whether they want to insist upon their right to not perform, and they chose not to. Whether they chose or just didn't exercise that right doesn't really matter. Seems likely they didn't choose because on the evidence they didn't know about the default until either the 17th of March. So there was no deliberate choice. They just continued to trade, presumably ignorant of the fact that the customer was in default. And my question is, well, so what? That doesn't mean that there's some other agreement in play.
I haven't had the opportunity to make the application that I need to in relation to the expert evidence, and this point itself is freestanding of those experts. But when I get to the expert evidence issue, I will be saying on the basis of that evidence that there is there are a mountain of reasons, or there is a mountain of reasons as to why what it is said was the case of knowledge only coming to Barclays by the 16th and 17th
well,
being.
Let's just deal with those arguments as one at a time. The argument that you're trying to advance now, as I understand it, is the proposition that because there was a default, and because under the clause you've taken me to, it would have been open to Barclays to refuse to pay because of the default. The proposition is that that means that there was some other agreement in play. Well, I don't understand the logic of that. I don't understand the legal process of reasoning for the reasons I've enunciated.
I'm obviously going to be guided by the court as to the way in which I deal with the questions of the court, but I would just say before I do so that the propositions being made in relation to the ISDA are not entirely unrelated to the experts, because it deals with the question.
Just tell me what the proposition. Just tell me what I'm trying to get from you is what the proposition is. Because if the proposition is, as I understand it, and that is that because there was some event of default, that somehow after the event of default, the transactions were occurring outside the ISDA, I don't understand that. So if you want to try and develop that argument, you need to, because I don't presently understand it, because it looks to me to be wrong. So I'm just throwing the gauntlet down to you, Mr. Trudeau, and it's a simple proposition. You don't need to go to expert evidence. It's a proposition of law. So tell me why if that's what you maintain, tell me why.
I'm sorry, I lost part of you then, but I heard to tell me why.
Well, tell me, if your proposition is as a matter of law that once there was an event of default, the transactions that occurred thereafter were not transactions in accordance with the ISDA, I don't understand that proposition. And it's not a proposition that gets any better by reference to expert evidence. I just don't understand it, because it just seems to me to be wrong. So if you want to rely on that proposition, you need to persuade me why it's right.
because by the effect of the absence of payment on the confirmed trade, the FX spot trade, that triggered the default, and because, or rather failed on the condition precedent because it was an event of default, and the continued trading arrangement after that had happened, and it was happening as soon as the 11th of March, must have been outside of the ISDA. Because
why? Well, I just don't understand that. As we've gone through, you've taken me to a clause which meant that the bank could have, had it chosen, the bank could have elected not to perform its obligations. It didn't elect to exercise its right not to perform following default. I don't understand why you say its failure to elect to exercise a right not to perform means that what was going on was outside the terms of the agreement. I just don't understand that at all.
The guarantee given by Mr. Shetty, whether one calls it just a guarantee or a guarantee and indemnity, the guarantee by Mr. Shetty was in relation to trades that took place in accordance with the ISDA.
No, it was in relation to banking transaction, banking facilities.
Agreement. I'm sorry, I didn't mean to talk over you. I beg your pardon.
No, it was, the guarantee was in respect of facilities or accommodation advanced under banking facilities.
And the FX trading agreement, which is the suite of documents, included the ISDA. That's not,
yes.
That's how the evidence of Mr. Homburger is put together.
Yes.
So it must follow that to comply with that arrangement, insofar as the ISDA was concerned, even though it was one of the constituent documents, it needed to be obeyed for the overall arrangement that Mr. Shetty was guaranteeing to stay the same.
Well, what do you mean by obeyed? What was happening was that trades were occurring. The bank elected, or didn't elect, the bank simply failed to exercise a right that it may have had to stop trading earlier. But it was still trading under the terms of the agreement, wasn't it?
No, because, sorry, with respect, no, because the condition precedent that no event of default were being breached in abundance by the 11th of March.
Giving the bank a right to elect not to perform if it chose to exercise that right, but it didn't. That's the point I'm making. The point that you agreed that's the proper analysis of that clause. The fact that the bank didn't exercise a right to elect until some days later I just don't see how you can say that that was that meant that the trades were occurring outside the agreement. Your client was in breach, the bank wasn't. The bank chose not to act on your, probably didn't choose, the bank failed to act upon your client's breach. That doesn't mean that it wasn't acting in accordance with the agreement, does it? I just don't understand that at all.
I'm struggling to see how they could just let all of these defaults accrue in the way that you described.
Well, they did. They did.
Well, they didn't do it, they say, willfully. They did it in ignorance. They say that they didn't know about them till the 16th or 17th of March. And I know that you have said that the expert material doesn't bear on that issue, but it plainly does, because the only evidence that we have, apart from Barclays say so, about the date that they should have had knowledge, or at least putting a case of probable knowledge or material from which to have knowledge is dealt with by the experts.
Well, the point I'm making is that I don't see how knowledge is relevant to your proposition. That's the point I'm making. And the experts can't give evidence about Barclays' knowledge. All they can say is that sometimes there are systems in place that elevate these things to somebody's attention. Whether or not that happened in this case is a matter of entirely speculative. The only evidence we've got is the evidence from Barclays to the effect they didn't know about the breaches until the 17th of March.
Yes, and I realise that's the only evidence.
One side. That's a whole other debate. What I don't understand is how knowledge is relevant in any way to the proposition you're trying to advance. Because I just don't understand it. And I think that's probably because it's not sound. But if you want to persuade me that it is sound, you'll need to do a bit more, I'm afraid.
Well, I mean, you've heard what I have to say about that part of Section 2 of the ISDA. If the court is going to determine this application on the basis that Section 2 and any number of failures on the condition precedent point doesn't create a situation where Barclays are allowing trading to continue in a default situation.
Well, no, Barclays work, but that's not your point. Your point is clearly Barclays did continue trading when there had been events of default. That's the evidence. There's no doubt about that. Your point is that somehow or other that gives your client a defence because the trades went outside the term of the ISDA. I'm
saying that on the basis. I'm sorry.
No, please.
I'm saying that on the basis of the test that's to be applied at this stage of application, and in light of the fact that there is no evidence apart from Mr. Homburger's say-so that they knew about this only on the 16th or 17th, he's not sure. There's not a sufficient basis to grant the application that's being made today. I don't need to show much.
What's the defence, Mr. Prudhoe? What is the ground of defence that you are pointing to?
Right. Specifically in relation to the ISDA issue, that for the reasons I've explained, by the early hours of the 11th of March, the conditions precedent that there should be no events of default were plainly not met, and whatever was happening by the 11th of March was out with the ISDA. That's what I have to say in relation to the ISDA.
All right, well, I understand the proposition.
In relation to you expressed a clear view as to the where the experts stand on that issue, but at the same time you say against me that the only evidence that there is.
I haven't expressed any clear view about anything the experts have said, Mr. Prudhoe.
Oh, let me rephrase. I'm sorry. I didn't wish to mischaracterize what you'd said. You say that, as I understand it, that on the question of the ISDA and the effect or not of Section 2 of the ISDA, the impact or not of the experts is not relevant, not helpful. But at the same time,
because I see that as a simple question of law. The question of law is whether once there has been an event of default, does that mean, as you contend, that all trades after an event of default must be outside the terms of the ISDA? Or does it mean, as I've put to you any number of times now, does it mean that the bank has simply failed to exercise a right available to it under the ISDA? Now, that's not I don't presently see how expert evidence can possibly be relevant to that question, which is a pure question of law.
Well, without wishing to belabor the point, in the context of saying that, you've said that the only evidence that there is of Barclays finding out on the 16th and 17th. If you're saying that that evidence also...
But what I did say to you, Mr. Prudhoe, was that I don't see how knowledge is relevant. That's my point. And I was asking you not to confuse the two issues. I don't see how knowledge is relevant.
On the basis
simple proposition
if one
you're
leaves
putting.
I'm sorry.
Yeah.
Leaving aside the question of knowledge and the date by which any bank run properly was aware of what was going on, leaving aside the electronic platform that Barclays operate and what that would generate in terms of notifications of unsettled, overdue trades, spot trades, piling up from midnight on the 10th of March onwards were the defaults, which I continue to submit fail Section 2. Now, separate and apart from the, I don't hang my case on the ISDA, separate and apart from the ISDA issue are the other aspects of, I'm sorry, please just bear with me. I'm sorry, I'm just looking for something in the document. So if I could ask you then, please, to turn to page D401.
Yes.
And then at the top of D401, you're actually looking at 9E Roman 2.
Yes.
The parties intend that they are legally bound by the terms of the transaction from the moment they agree to those terms, whether orally or otherwise. And then it talks of the confirmation. So the confirmation that has the deal date and the value date is what should have happened. And whatever didn't happen, whatever other thing happened instead, is some sort of modified version of the relationship that was supposed to be governed by the ISDA. So if one looks at
it was simply the bank failing to exercise the right that it had to terminate.
Oh, but there's another reason why it's important for the bank to behave in the way that's dealt with in 9.2 and also therefore in 2 and also in 9E Roman 2, because these obligations, and I'll be careful, I'm not saying he guaranteed the ISDA, he guaranteed, Dr. Shetty guaranteed the FX trading arrangements. I think that's the phrase. His obligation obviously is based upon the documents that that relate to the obligation that he is guaranteeing being observed. There is a safety aspect for Dr. Shetty or anybody else guaranteeing for the conditions precedent to be considered relevant. Whatever happened
But Mr. Trudeau, it was a condition precedent to the bank's obligation to perform. The bank chose to waive compliance with that condition precedent by its conduct, as it was entitled to do. That's what happened.
Well, but by March the 11th, there were trades, FX spot trades in abundance that were trades in default of the ISDA.
I know, that's the point I'm making. That gave the bank a right to elect not to perform because of non-satisfaction of the condition precedent. It chose to waive that right. It didn't exercise that right. So what? That's my point.
Well, we say that creates a situation where the arrangements have changed sufficiently,
Right.
or the doctrine of purview. We don't need to say much at this stage to make out. There's no disagreement as to the test on an immediate judgment application. And it's clear, whether the court takes the view that this was just a bank taking the position that it was able to, it's clear that there was an arrangement where the defaults were tolerated for the period, well, from the 10th of March.
I'm just going to make salad with chicken. But can you just show me where everything
Somebody's
is?
left their microphone on.
It's so jam-packed.
Somebody's left their microphone on. Would somebody out there who's got a microphone on turn it off, please?
Right, well, not having salad with chicken, but to answer your direct question, where does that, what's your defence? On this particular issue, we say it gets us to the gates of purview, and I don't need to go any further for the purposes of this test. That's what we say about the ISDA. We say that they just simply deviate from the terms of the ISDA, and we would say that we have a whole lot more to say about that and the context in which it happens with the benefit of the experts' evidence. So I don't know, now that I see my learned friend's position on the experts, I don't know how far through a formal application for the experts' evidence to be admitted you feel it would be helpful.
Well, as I understand it, the claimant's position is that without conceding relevance, the 3 expert reports can be received by me, as I say, without conceding relevance, but there is objection maintained to I think it's the 3 pillars report. Have I got that right, Ms. O'Sullivan? So Mr. Trudeau, you're pushing an open door in relation to 3 expert reports, and I will grant the application to receive those documents but reserving the position with respect to their relevance for future determination. But I need you to persuade me that I should receive the report relating to the solvency, or if you like, the solvency, the prudential security arrangements of the bank. I just don't see how that's relevant. How that could possibly be relevant.
So in relation, I think you're talking about Professor Alexander.
No, I'm talking about the 3 pillars report.
The 3 pillars report, that's actually in relation to, that's as evidence not from the experts. It's obviously a document of the banks, but it's put into evidence by Mr. Federigoli, and that's his second witness statement. So that's a separate application. That's an application that we only made when we found out eventually that there wasn't agreement on that, and that evidence has been with the bank's lawyers since the 17th of December. Now,
well, just tell me why it's relevant.
Well, the relevance And the reason I was a little unclear as to my learned friend's position on the experts, and I'm not going to make an application that's not needed, is usually relevant, is the basis upon which you object, rather than accept the evidence and then claim it's not
we've
relevant.
dealt with the experts. We've dealt with the experts. Forget about them. Please don't waste any more of our time talking about that application. Tell me why the three pillars report is relevant. I'm sorry?
I have tried to give us a sort of summary of the main parts of Pillar 3 that are relevant in the back, almost final stages of my second skeleton argument. But it demonstrates the infrastructure, the risk infrastructure right across the bank that they boast about, in effect, and I don't mean that in a critical way. There are obligations brought in post financial crash for everybody, and Pillar 3 deals with the escalation. It deals with the extent to which there are presentations internal to Barclays on risk. It deals with the sort of lines of escalation that there are: risk, legal, compliance, wherever there are, well, in particular FX, it deals with for purposes of this, but it deals with the whole approach that Barclays claim to take to the risk issue. So I have to satisfy the court that there are documents that are out there that are likely to exist that would have an impact on a judge's view of these issues at a trial if it went forward in that way. And if one even leaves to one side for the moment the experts, the three experts, and I'm talking about the financial, the banking, and then the media material, Barclays' own evidence, Barclays' own materials give a clear idea as to how much there is in terms of Barclays' own setup for it to be implausible that between the 10th and 11th of March and the 16th or 17th of March, there was no knowledge in the hands of Barclays that these defaults were taking place.
All right, now tell me why knowledge is relevant.
Well, because I've been described as being on very thin ice. I'm not clear as to what allegation it's believed I am making. And I'm not
perhaps
sure.
You just tell us what allegations you are making, because it's not clear to me precisely what you're saying, having read the two skeletons. Right, I just want to know what your defences would be. Where you point to the possibility of a defence. What is that defence?
Well, you've heard me on the ISDA in relation to the implication that there is some sort of veiled allegation of fraud. I've even put a section in there entitled the fraud allegation red herring. I'm saying that there are circumstances which include, for example, the Pillar 3 report and the analysis of the trader expert, Mr. Vitri, that make it clear beyond any sensible argument that there will be materials that would shed light on what level of knowledge Barclays has. Now,
but Mr. Prideaux, that's not the question I asked you. The question I asked you is, how is Barclays' knowledge relevant to any defence for your client?
Well, I think now we are in helpful territory in the sense of explaining the experts. Knowledge is relevant because what we say is the very one-sided amount of evidence that there is before you that point to knowledge. If they are in knowledge, the assumption would be that they would stop this happening. If they or that there's been some sort of manual override, certainly that they couldn't be ignorant of it. At this interlocutory stage, all the court needs to be satisfied about is whether material to confirm that there was that knowledge exists. We need, in a sense, to know why.
You're just not answering my question, Mr. Prudhoe. How would knowledge? Let's assume that there is material that shows that knowledge was gained somehow or other earlier than the 16th or the 17th of March. My question is, how would, and I've asked it 3 times now, how would that lead to any defence on behalf of Dr. Shetty? What do you say the defence would be that would flow from some contrary finding of knowledge that's contrary to that which is asserted on the evidence?
Well, because it's a very difficult question to answer succinctly. Depending on what that knowledge shows.
Mr. Prudhoe, you have, because of the way the bank has conducted its case and established a strongly arguable case, you've got to point me to some line of defence. So it's a fairly obvious question that I think I'm entitled to ask, and you need to answer it if you want to resist judgment.
I was trying to answer it and will continue to do so. There are obviously different types and levels, gravamen, if you will, of knowledge. Obviously, there's a difference between incompetence, so demonstrating a failure of systems at one end of the scale, as contrasted to, and I'm not making this allegation, I'm trying to answer your question, as contrasted to or from some sort of behavior within Barclays, which I cannot identify now, some sort of behavior within Barclays that make it clear that there was a conscious decision for reasons that we don't understand and won't if you give summary judgment now, immediate judgment now, as to this trading continuing. I have not said, even by implication, that I can point to a rogue trader. I'm just trying to say, on your question about knowledge, that if that sort of behavior exists, and clearly the attempt that's being made is to stop us finding out anything, but if that sort of material exists, the scale of the breach, the scale and seriousness of that behavior could potentially give rise to defences in the public policy context. And I don't accept...
What public policy? What public policy?
Well, public policy is a fairly elastic concept, but...
Well, I want you to tell me that's why I ask you to identify what aspect of public policy you say would be invoked.
Well, the scale... Obviously, I'm having to deal with a hypothetical about what the material could potentially include. But if in this situation the relevant financial institution had bad actors some way involved, and to be clear, before more is said about the ICE, I'm not in a position to say that, but if that's what it was, the public policy there would be the scale of the regulatory breach. Regulatory breach, there doesn't need to be illegality for the illegality defence to arise, perverse as that sounds on its face, and the cases make that clear. In fact, then Justice Sumption discusses it in the Apotex case, the difference between illegality, he calls it immorality, and the range of things that can lead to what he uses the phrase as judicial abstention. That range of behaviours is not a closed range, and all of this would be viewed, the lens through which a trial judge would view this would be of a systemically important regulated bank.
But let's say there's been a breach of the regulatory regime, and I'm not saying the evidence goes that far, but let's say, for sake of argument, that the bank was in breach of the obligations owed to the regulator. How does that give any rights to your client?
Well, I mean, the Mahmood case, the oilseed rape case in the 1920s, talks about breaches, regulatory breaches, import breaches there, and how that would stop enforcement of that contract. The question of whether or not...
That's an illegal contract. There's no suggestion this contract was illegal. What you're saying is that as between the bank and the regulator in the performance of the contract, there's been some breach of a regulatory obligation owed by the bank to the regulator. That's a very different situation, isn't it?
Well,
I just don't understand how that would give any right to your client.
I accept that case is a different set of facts, but I don't know, and this isn't some sort of Macaubress something will turn up position. I don't know the seriousness of the breaches, and we're not going to find out if the matter ends here.
Well, we know what the trades were. We know that there was trading for a period of perhaps five or 6 days.
But we don't know why.
Well,
why? I mean, your answer or the court's answer may be, well, because the bank could let that happen. But that's only a quarter of an answer as well, really, as to why, not how, but as to why it was able to happen.
But my question is, when we know what the why is, how could that possibly give your client a defence? You mentioned the first answer you gave was public policy, and I'm struggling to see how it would be consistent with public policy to allow a debtor to evade its debts simply because there's been a breach of regulatory obligation between the bank and the regulator. That doesn't seem to me to say, oh, well, therefore the customer doesn't have to pay the bank the money. That doesn't seem to me to be a public policy that's likely to be adopted by a court. And the other two things you're saying, well, if we get knowledge, then we might, the answer to the why might be that there's a rogue trader who was looking for personal gain, and then but you shy away from that. You say you have no evidence of that, and that's certainly right. And then in the first skeleton, you said your first skeleton you referred to fraud. Well, there just doesn't seem to be a jot of evidence to suggest there's any fraudulent conduct.
Well,
I'm just trying to see where all this goes.
I just want to be very clear about what it is said that I am accusing anybody of in the first skeleton. I tried to make it clear in the first skeleton that there was not scope to articulate a pleaded claim in fraud. And then I had a separate section on the same issue dealing with the correspondence to make it clear that no forgery allegation was ever made. Section 25 and 26. The court has fairly asked me, where can any of this go? And I'm trying to answer the question along the lines of, if this presents material that deals with a bad actor or more than one, that may potentially give rise to a basis as a public policy matter for Mr. Shetty's guarantee not to be enforced on that basis. Now, if there was a deliberate breach of the regulations governing the bank, that would clearly bear on that. Now,
why?
It's simply
why
not
would it clearly
enough.
bear on that?
Why
would it clearly bear on? Why would it clearly bear on the enforcement of Dr. Shetty's obligations?
Well, it's again, I'm trying to trying to answer that to a hypothetical. It would depend on what that material said, but the bank is clearly not the regulated bank, and Mr. Federigoli exhibits to his second witness statement the Bank of England fine of Citigroup. One can see what happens when a bank subject to regulation gets it wrong. I just don't know how, and I can't know at the moment how wrong Barclays have got it.
But my
my
question is, no matter, to use your language, the extent to which Barclays got it wrong, my question is, how would that afford any defence to Dr. Shetty? There was a breach of the regulatory obligation between the bank and the regulator. How does that give Dr. Shetty a defence?
Because in that, well, it's not a defence. In Jonathan Sumption's language, it's judicial abstention. But your question, I suppose, is really on what basis would it be likely that that sort of abstention would be exercised in favour of Mr. Shetty? Sorry, I beg your pardon, Dr. Shetty. Well, it would be on the basis that whatever had been done, which I don't know, and we won't without disclosure, led to the scale of default for which the guarantee is being invoked. And you will have in mind, the court will have in mind the cases on illegality, the Patel case, the subsequent, if I'm pronouncing it right, Drondona Stoffel case, the underlying purpose of the prohibition, whether or not relevant public policies have been weakened, and in Drondona, and I deal with this in my own skeleton arguments, and I can give you the reference in the authorities. Justice Lloyd Jones says the essential question is whether to allow the claim would damage the integrity of the legal system, and the reference for the case itself, it's in, so you have it, it's in G, obviously, and it's G31, it's the document page G436. We just don't have enough information at the moment to deal with how we could say whatever it is that led to this helps Dr. Shetty. We just don't have enough. Your question presupposes that there's no behaviour bad enough on the part of the bank for Dr. Shetty to have recourse to or try and invoke the idea of the judicial abstention. Well, we don't accept that as a matter of public policy. There's nothing that Barclays could have done. No bad act too bad, or bad enough, in fact, sorry, for Dr. Shetty to have recourse to those arguments. So those questions came out of whether or not you felt that material exhibited to the second witness statement of Mr. Federigoli were relevant. And we say for those reasons that they are. And even without the experts, the idea I would ask the court to consider the concept of banks being regulated is something of which the court could properly and should properly take judicial notice. Public policy also bears on the question. I don't know if you would like me to. I'm sorry. Public policy also bears on the question of the indemnity and conclusive evidence clause. And in fact, it's accepted in the skeleton argument. Well, sorry, I beg your pardon. I beg your pardon. I may return to the ISDA just briefly. Public policy, I'm sorry, I should say in relation to the ISDA, the trades post the 11th of March, so by which stage the defaults are in under section 2, although I don't intend to revisit that. If they took place as a result of failures of whatever nature by the bank, and on the basis that one treats them as separate transactions, those separate transactions were taking place in the face of regulatory breach. At least regulatory breach, because we don't know any other circumstances in which those were taking place. Back to the bad actor or potential bad actor points. There's scope there to bring that argument back to the question of possible illegality and the public policy issue. If I could deal then, please, with the public policy impact on the indemnity and the conclusive evidence clause. I should say, and was saying, that the bank accepts that in relation to the conclusive evidence clause, public policy can impact, and they quote from the Singapore case. We say, for the same reasons that regulatory failure can raise the question of public policy itself, so too can the regulatory failure, which we don't have discovery of or in respect of, can also impact directly the conclusive evidence clause. Public policy would then be impacting a potentially tainted set of transactions. We don't need, as I said before, we don't need actual illegality for Justice Sumption's judicial abstention, and there are examples of that in the authorities. The damage to the integrity of the legal system, Justice Lloyd Jones's threshold, paragraph 102 of my second skeleton argument at A66. We're not saying that any of this is a plain and obvious case to exercise judicial abstention. I feel as though this is a trial in some respects. I don't wish to sound discourteous. These are obviously very important issues, and we are at a very preliminary stage, doing what we can with extremely limited material in the face of an implausible denial by a very large financial institution which markets itself, or at least polishes its public image as being adherent and well systemed, if that's the right word to use, well set up for safeguards and with safeguards in place in relation to risk, both on the risk side as well as the legal side. The denial of our position today, the regulatory bragging, if you will, of the bank in the context of just shrug of the shoulders to say that they didn't know anything between the 10th and the 16th of March, just doesn't make any sense in the abstract. When one applies the experts' evidence, it becomes all the more odd. We don't even know how it was, we still don't even know how it was that they found out on the 16th or 17th of March. I mean, this is an extraordinary situation, and with large amounts of money, and even if one applies a general commercial framework, it doesn't make any sense either. You've seen the confirmations, you've seen the fact that they have the value and due date matching. If one has a trading framework that expects settlement within a particular period, let's say you're selling potatoes or frozen orange juice or whatever commodity you were selling, and there was a 30-day or 60-day or 90-day trading period, and you simply ignored it, it would be an extraordinary situation. So it's just not plausible that there were not arrangements in place to have found out by the 11th of March. Now, your answer to that would be, I realise, well, they may have been perfectly happy with this, and the only effect of Section 2 is that they were simply making a conscious decision to forbear, in effect, not to enforce their own rights. Well, that's an interpretation. We just don't know what happened. And we don't know whether or not, for example, as I cover in my skeleton argument, there is a disconnect between the way that somebody who works the Forex desk, although we are told it's fully automated, has a positive incentive to keep going. We just don't know. So to say those things is not to make some sort of allegation of fraud that we can't sustain. It's to say again that we will be shut out of this knowledge. Can it be the case that they were just happy and continued to trade? Even the escalation. If they have such a good financial...
You seem to me to be saying the same thing over and over again. Is there some new point you're making here? Because if it is, I can't see what it is. It seems to me to be a lot of repetition of what you've already said. If there is some new point, perhaps you could identify it for me.
Those are the points I'd wish to make. I wonder if the court could rise just for a few minutes, please, or at least break for a few minutes.
Yes.
So I can take stock if anything else I wish to raise.
Yes, well, it might help if you do that by, as I understand it, Mr. Trudeau, the points you make are these in answer to the application. Firstly, there's the banking facilities point. The second is the missing 27 pages point. The third is the, if you like, trading outside the terms of the ISDA point. The fourth proposition, as I understand it, is that there ought to be a trial in order that we can find out what happened between the 10th of March and the 16th or 17th of March, and that might possibly feed into a public policy defence. And the fifth point is that, for the same reason, there might be a public policy issue in relation to the conclusive evidence. There ought to be a trial to find out what happened between the 10th and the 16th of March, because that could have an impact upon the conclusive evidence point. Now, is that it? Are those your points?
I want to make sure that in your summary there, you understand that I am saying that as an effect under the ISDA, we reach the sort of jumping off point in relation to purview. So we get to a stage where there has been a at least a variation of the ISDA or some other trading arrangement. So I just want to be clear that you have that in your list.
All right. Well, subject, yes, I accept that. Thus modified. Is that a fair synopsis of the points you made?
Yes, but I would ask, please, just a few moments.
Yes. All right. Well, Ms. O'Sullivan, the question I'm going to ask you, and you don't need to answer it now, is just in relation to this so-called missing 27 pages. It seems when you look at the documents that the document that we have at D388 can't be the same as the document that was signed in 2013, January 2013, because it's differently formatted. So I understood you to say earlier that the document that is in evidence, that the signed document in evidence, is actually a version of a fuller document. Now, why haven't we got the fuller document? Why haven't we got, you say it was, for economy of space, but is it your instructions that there is in fact a document that is a fuller version of the signed ISDA that includes the master agreement within it?
Yeah, my lord, I will take instructions on that. I believe I may have misspoken when I said that it was for economy reasons, because my instructions are that the full template was in fact exhibited with the original affidavit, Mr. Homburger, so that can't have been the explanation. I will find out. My point would be that it makes no difference, because the missing section are simply the standard template wording that anybody has access to.
Well, how do we know? That's the problem I've got with is how do we know? Because it's clearly not. It's clearly not the same document as you say ought to be included there. How do we know that there isn't a different version of that document?
Yes. Well, the reason why it looks different is that what's been put in is the standard template that's currently available that you can download from ISDA if you pay them the requisite fee. I mean, that formatting may have changed a bit since 2012. That's not to the point. The terms haven't changed. It's the same terms.
It's just that the problem I'm having, Ms. O'Sullivan, is that you're asking me to enter immediate judgment for an awful lot of money on the basis of what appears to be an incomplete document.
Yes.
And that,
my lord,
that
I will take instructions.
Yes.
I will take instructions to see if I can reassure you on this, my lord. But,
Council,
yeah.
will 10 minutes be sufficient for both council?
Yes, thank you.
Yes,
all right. We'll resume in 10 minutes.
I apologise if I've kept the court waiting.
It's fine. Mr. Prudo.
Yeah, I just wanted to clarify what I said in relation to transactions at the beginning. I was a bit thrown, perhaps, by the change in position, as I understand it to have been, of the bank now calling these derivatives, which we don't accept, and we don't accept the absence of a definition. So when I initially said that I didn't accept that these were transactions, I misspoke. The consequence of these being a set of separate transactions, if that's how they are described, is we would say that they are themselves breaches under the ISDA, and we would also say that the way in which they are characterised,
breaches by you.
Well,
breaches by the customer.
Yes, well, they are breaches under Section 2 in the way that you have described them back to me, but they are breaches by failure of a condition precedent. And these transactions, if we take them to mean that, and we would say that the court is entitled to understand where within the definition of banking facilities the bank says that these fall, the effect of the breach under Section 2 by AEUX, UAEX, meant that these transactions, if that's what we take them to be, and we don't accept that they are derivatives, all that post-date the 11th of March, we say must have been transactions that weren't in accordance with the ISDA, which gets us to the question of what it was that the arrangement was, which gets us to the question of the purview.
Yes, all right.
And by saying gets us to the question of purview, you are understandably concerned to hear from me as to where is our defence, as it were. That is one of them. The other one is something that you have raised yourself. Well, I say we don't rely upon the absence of the agreement in the sense of it being some sort of get out of jail free card, but it is certainly something that is an extraordinary missing in action document for the purposes of today. But we still have never had an explanation, and we have really tried. The extent of the attempt is set out in extensio, perhaps almost ad nauseam, but very detailed in our second skeleton argument as to our attempts to get page 2 to 27 of the document upon which reliance is now being placed. We still don't know where that document is or if it still exists. So we will be very interested to hear the learned friend's explanation of the position. Of course, I should say we have no way of knowing, and I don't overstate this, we have no way of knowing whether that document has remained unchanged. We just don't know.
Well, we do know that it has the same heading as the other document, don't we? And it's dated 2002.
Yes, but we also know.
So if there was a variation of the document after 2002, you would expect it to bear a different heading, wouldn't you?
Well,
no, Ms. O'Sullivan's shaking her head.
Well, if there's a copy for us to see, that may answer everything.
Yeah. All right. Well, we'll wait and hear what Ms. O'Sullivan has to say. I won't say any more about it.
We just don't know, and then that's the problem. We just don't know. We don't know what points we would raise in relation to that document, and we're here in a position defending an application for immediate judgment. It seems an extraordinary document to well, to have not provided, let me put it that way. And I hope, although less easy with screens next to each other, I hope that you and obviously from your question you did, realise that if nothing else, they're differently formatted documents. We just don't know whether it's changed. So subject to news on that, that's what I wish to say. Thank you.
All right. Well, I've 2 matters I want to raise with you, Mr. Trudeau, and I will be reserving my decision because I think I need to write some cogent reasons because of the likelihood of some form of review. But in relation to costs, you've seen the claimant's statement of costs. Do you have any submissions to make in relation to that?
Yes, I do. The cases make it clear that even with a contractual clause, it doesn't usurp the discretion of the court as to the cost shifting issue. That the GOMBA
so what
should I do in relation?
What should I do in relation? If I was to grant judgment, what should I do in relation to the costs in your submission?
Well, if you were to grant judgment, and if you were to make an order adverse to Dr. Shetty, and I think you're asking me about my view on the schedule, certainly a schedule of that scale should go for a detailed assessment. It is an extraordinary amount of money for a single, if you're looking at this application and not even the application for the freezing order, we're looking at one witness statement with some documents which they say are very ordinary documents and nothing else.
All right. Well, all right. So you say it should go off for assessment. All right. The second question is the permanent freezing order or the post-judgment freezing order. Your only issue in relation to that is allowances for living expenses and legals. Do you have any submissions as to if I was minded to include provision for that? And I know that Ms. O'Sullivan submits that I shouldn't. Are there amounts that you would nominate that I should include if I were to view that proposition with favour?
No, because and I don't think that there has been controversy over this before. The last form of order had reasonable, had the word reasonable, and there's been no dispute about that. My learned friend and I haven't canvassed figures, but I would ask for similar language.
All right. All right. All right. Well, thank you, Mr. Trudeau. Ms. O'Sullivan.
My lord, on the point you've raised, let me. There are a couple of things I want to say about the ISDA master agreement. So there are two versions of this document. There are the 1992 terms, and then there are 2002 terms, which were entered into because there was some market perception that the 92 terms didn't cater for all the problems that arose in practice. So that's an amended version. Now the parties can elect as to which version they choose, and in fact now most parties would choose the 2002 versions. I mean, when you say they're dated 2002, it's not a sort of agreement dating from that time. It simply tells you this is the template reference to the 2002 terms, like you might refer to the ICC arbitration rules 2017, for example. It tells you which version. And so there are people entering into agreements even now on these terms.
Well, that's the point I think I was making. In other words, if there was a third version after the 2002, you would expect it to bear a different heading.
Yeah,
the one that is in evidence.
There isn't, and there is no ambiguity when people refer to the 2002 Master Agreement. They know exactly what is being referred to. That document is publicly available. You can go onto the ISDA website and you can purchase a copy of the template and use it. And in fact, all trading entities have a copy of it. And it's always the same.
The problem I'm having, though, is that I'm hearing all this from the bar table, and I've got to act on the evidence. And on the evidence, I'm being asked to enter judgment for $131 million US on the basis of a guarantee that relates to a facility and which on the evidence is recorded in an incomplete document. And I don't know why it's incomplete. There's
Right,
no
okay.
evidence explaining to me why it's incomplete other than what you say from the bar table. So that, I suppose the question is there a complete version of the document? And if so, why isn't it evidence? And if there is a complete version of the document, why shouldn't it be put in evidence?
Okay. On that, my lord, the factual question: is there a complete version of the document? We are checking the file, but in the 10 minutes we haven't been able to. But I'll explain why it doesn't matter shortly. But I mean, the inference would be that it was, and probably what happened is only the signature pages got scanned and sent back. But there is not in front of you a copy of the agreement, which includes the 27 pages that were part of that agreement. But I say, well, that doesn't matter, my lord, if you actually look at page D354.
D.
D354.
Yes, just bear with me. Yes, I've got it.
Yeah, so it's quite clear that the parties are intending to enter into terms, a contract on the terms of the 2002 Master Agreement. So it's incorporation by reference, a very well-known and publicly accessible standard form document. In a way, for example, I mean, suppose parties had bought a transaction for sale of goods and someone had said, we supply on our terms and conditions, which are to be found on our website. In my submission, it's not actually necessary to actually recite each and every term of the standard form template, provided it is sufficiently clear that the parties intended to incorporate those standard terms, which, as I say, are publicly accessible on the internet. And so that's the position. It's completely clear, both from this and from the schedule, that the parties intended to enter into a contract governed by the 2002 terms. That is sufficient in my submission, even if there weren't an extant copy for whatever reason. We will ascertain the position, but even without it, it's not necessary.
Well, it would help me to know if there is an extant copy, I think, again, simply because of the scale of the judgment that's being sought. I think it would be good if the T's were crossed and the I's were dotted.
Yes.
And so I think it would be desirable to receive further evidence on that question, whether there is an extant full copy, and if there isn't, for an explanation as to why there isn't.
Thank you, my lord.
Or
well, you've indicated.
That can be identified. Yes. Now, could you produce evidence of that within? How long would you need to produce evidence of that?
Could I have 48 hours?
Oh, you can have longer than that, Ms. O'Sullivan. I'm going to, as I said, I'm going to reserve. I'll need transcript, which is usually 7 days. So why don't you have a week?
That's very helpful, my lord. Well, that's extremely helpful.
And indeed, we'll give you till. Why don't we give you till? I know that your working week will probably be a little. Yours and your client's working week will probably be a little different to that in Dubai. So why don't we make it Monday, the whatever it is, the 1st of February?
Yes. Close of business. My lord, that's extremely helpful, and we will do that. Thank you very much.
And Mr. Prudo, obviously, you need time to respond to that,
Yes.
either by evidence or submissions or both. Would the 8th of February be satisfactory for that?
Yes, it would. And I should say, without any discourtesy, we don't accept as a matter of principle that this is crossing T's and dotting I's.
Yes, yes, indeed.
Understood.
And I don't think, Ms. O'Sullivan, you'll need to respond to anything Mr. Prudo says, but I'll look at the material. If I think you do need to respond, I'll give you the opportunity to do so. But I think we can leave it at that, and on the basis that I don't think there needs to be a further hearing following that. The evidence will be what it will be, and Mr. Prudo can put on whatever submissions he wishes as a result of that. Now, Ms. O'Sullivan, what else would you like to say in relation to the other matters raised by Mr. Prudo?
Just may I say, there was one point, I think it was your Lordship's 5th point, which is the public policy and the conclusive evidence clause. I think there's been a misunderstanding. The public policy, which is invoked in relation to the conclusive evidence clause, is that such clauses exclude the jurisdiction of the court to decide what the amount outstanding is. And that's the argument that's been rejected, well, frankly, in Australia and in Singapore. on the basis that the parties are bound by their agreement. So that's that point. Now, the other matter, so costs. I mean, I don't want to get into the full argument about the costs, but the position is this: that as you know, we are claiming a contractual right to indemnity costs, and my learned friend is quite right to say that, of course, it's. I mean, first of all, I'm presuming that you'll make an order for costs. I'm making all these submissions on that basis.
Yes.
But assuming that you do. Yeah, well, quite. There you are. So we would say that.
But sorry, just I'm sorry to interrupt, Ms. O'Sullivan, but it seems to me that if you are asking for the contractual right of indemnity, you'd have to put on evidence to show what costs were actually incurred. Whereas at the moment, I've got a statement of costs that is an assertion. It's a claim. It's not evidence. So,
I believe I believe it's signed with a statement of truth, my lord.
It is signed, is it? Oh well.
I think it's.
But anyway.
They are required to be verified by a statement of truth. I think it does have evidence.
I think that's right. I think you are right. But in any event, there is the principle that even in such a case, the court does have a residual capacity to review. Do you disagree with that?
No, not at all. I mean, just saying that. No, costs are in the discretion of the court, and the position on the authorities is that usually the court should follow the contract. I mean,
but the amount claimed is on the face of it exceptional. Yeah, given that we've only got to immediate judgment.
Yeah, it is the cost of the whole case, my lord, including the freezing order. It's the whole case from start to finish, which is within your scope. You can make a summary assessment. You're entitled to under the rules. If you don't, that's another. If you don't, I'd be asking for an interim payment. But we can. I mean, that's why it's a large figure. But can I just also draw your attention to the provisions of RDC Rule 3869?
Yeah.
So that's in relation to contractual costs.
Yes. Can you just help me? I don't have it to hand. Can you just read it to me quickly, Ms. O'Sullivan?
Well, it says where the court assesses costs payable by the paying party to the receiving party under the terms of a contract, the costs payable under those terms are, unless the contract expressly provides otherwise, to be presumed to be costs which have been reasonably incurred and are reasonable in amount, and the court will assess them accordingly. In other words, we have the benefit of a presumption that the costs have both been reasonably incurred and are reasonable in amount.
Right. Well, Mr. Prudhoe, would you like to challenge? Would you like to reserve the right to challenge that they are reasonable that they were reasonably incurred and reasonable in amount?
Yeah, we certainly challenge that.
All right. Well, I think that suggests to me that it's got to go off for assessment to a registrar then, if you want to exercise that right. But
yes,
I'll think about that some more. Ms. O'Sullivan, is there anything else you want to say on the question of costs? And what about the freezing order?
Well, first on costs, if it's to go off to detailed assessment, the default rule is that the court will order a payment on account of costs. And I would ask for a payment of...
And the usual thing is 50% of the amount claimed, isn't it?
I'm in your lordship's hands. I was going to ask for 65%, but if you say 50% is the order you're minded to make, I will take that.
There's a practice direction that relates to 50%.
Yes. Well, I'll take 50% then, please, my lord.
Yes.
I'm sorry, and
obviously
sorry.
Mr. Prudhoe, is there anything you want to say about my exercise?
I'm afraid I'm a little lost now on where we are. Are you about to make?
Let me explain it to you. Ms. O'Sullivan is accepting the likelihood that I may make, instead of fixing the costs, if I do grant judgment against your client, which hasn't been decided yet, but if I do grant judgment and order, yes, no, I've not decided that, but I'm just covering, because we're not going to come back and reconvene. I want to cover all the contingencies because I'll just produce a written judgment. But if I do grant judgment, then obviously I would order your client to pay costs. The question is whether I fix costs on the basis of the claim because of the contractual indemnity in respective costs. If I conclude that I shouldn't do that, as you submit that I shouldn't, and should give you the opportunity to challenge the costs before a registrar of the court, then the question is, should I, in the interim, order your client to pay 50% of the amount claimed?
Thank you. I understand now. Yeah. The scale of the costs sought, I don't know if you've
I have seen them.
Anything apart from the bottom line, as it were, is so enormous that it would be an inappropriate thing to do even to give 50%. And the court will obviously accept as a conceptual matter, you don't just get 50% of any figure that you ask for. There has to be a degree of scrutiny. So well below 50% if we got to the stage of an order for costs. It is a eye-watering amount of money, and even 50% of it stings the eyes.
Yes, all right. Thank you. Now, Ms. O'Sullivan, the freezing order, if I understand you say that post-judgment's different to pre-judgment, so therefore there shouldn't be an exemption for living expenses and legal costs.
Yes.
But if I was against you on that, would reasonable living expenses and reasonable costs be satisfactory, or should I specify them, and if so, in what amount?
I think it should be on the same terms as the existing order. I believe there is actually a monetary figure for living expenses, which I thought
there was too. Oh,
yeah,
well, I'll check that anyway.
The same one. The same one. My lord, just on the cost, can I be absolutely clear? So you are minded clearly to order a summary assessment, which is fine, but I would ask you to order that we should be entitled to indemnity costs in principle in accordance with the contract. Now, of course, on the detailed assessment, then it will then be presumed that our costs are reasonable, but it's open to my learned friend to seek to rebut that presumption. That's how it works.
That's as I understand it. That's as I understand it.
So if
the costs will be ordered on an indemnity basis pursuant to the contractual indemnity, but on the basis that pursuant to the rule of court, you've indicated to me there's a presumption in your favour, but I assume it's rebuttable.
All presumptions are, my lord. Yes. So yes.
Yeah. So then the onus will be on Mr. Prudhow's client to rebut the presumption in favour of indemnity costs.
Exactly, and we're seeking the interim payment. Yes. I think. Yes, I think that was it. I don't have any further submissions.
All right, thank you. Mr. Prudhow, anything more?
The only thing that it would be useful, I think, to clear up, and I can see why, but I don't think the injunction itself is in the hearing bundle. But I don't believe it's right that there is a figure, and there may be value in me just finding the document to confirm that. So if you could bear with me for just a small moment whilst
why don't you drop us a note on that, Mr. Prudhow?
By all means, yes.
Yes, rather than take time now. Well, if there's nothing else,
find it quickly enough, but yes, I'd be happy to do that.
If there's because it won't be in the hearing bundle, you have to go into the court file and so forth. If there's nothing else, then I'll reserve my decision to be published in due course. In the interim, there will be liberty to the claimant to file an affidavit not later than the 1st of February relating to the ISDA master agreement executed, I think, in January 2013, and by the 1st of February, and there'll be liberty to the respondent to put on any evidence and submissions in response to that evidence by the 8th of February 2021.
Not to deviate from any of that, I have found the order and I stand corrected.
Yes.
My learned friend is absolutely right. At the top of page 4 of what I understand to be the current order, there seems to have been 2 different orders made that day. I'm looking at the one that was granted at 7 p.m. Perhaps they're 2 different versions of the same document, but
it's B19.
Exceptions to this order at 4.1.
B19.
There's a $10,000 a week towards his living expenses and a reasonable sum on legal advice and representation. I would be asking for that to be continued.
Yes.
So that paragraph again, I can just perhaps read it out. It's at page 4 of the order, paragraph 4, subparagraph 4.1, under the headings exceptions to this order. This order does not prohibit the respondent from spending US $10,000 a week towards his ordinary living expenses and also a reasonable sum on legal advice and representation, full stop.
All right. Well, if I'm minded to make an order in those terms, if I'm minded to grant that provision, I can't see any reason why I wouldn't do so in the same terms.
Oh, right, thank you.
Is there anything else, counsel?
No, thank you.
No.
All right. Well, thank you both, counsel, for your assistance. I'll deliver my decision as soon as I can.
Thank you.
Thank you. Call now adjourned.
Bye-bye.